Your office for inviting me here once again, and it's always a great pleasure to come and talk to you and the OSCE. I started back in 1996 working in the field of internet policy and fundamental human rights, and at that time one of the first reports I have written was about the pressures the internet access providers at the time facing from the British police in relation to removing child pornography from their servers. So my report was entitled "Who Watches the Watchmen?" and looking into not just their role and liability, but how these issues affected users, because I come from a perspective of protecting users' rights. And so in time, of course, internet access providers turned into internet service providers, and its impact on e-commerce and other issues. But in the last few years or so, we started talking about the role and importance of intermediaries, especially the social media platforms, the YouTubes, Facebook, Twitter, and the others. And because the internet, as we know now, become much more user-driven. And so in that point, it is important to emphasize that protection of universal human rights is not only the obligation of states, but also of companies that engage in transnational activities, so the intermediaries. And it is evident that states have an obligation to respect rules pertaining to human rights recognized by international conventions like the European Convention on Human Rights. And however, today some corporations have the potential to violate human rights as severely as any government, if not more so. For example, if the exemption of an oil company from environmental regulations in a country is not regarded as a human rights issue because of its financial power, the right to a safe environment will be rendered meaningless. Internet service providers, including social media platform providers, or the intermediaries in short, and their activities in the fields of freedom of expression, science, art, and even the right to hold demonstrations and marches are of a similar nature. In many countries of the world, people convey their speech to others through social media platforms developed by these companies, often based in the United States. In cases where social media companies cooperate with political powers, I come from a country like that, Turkey, for example, that exert political pressure on their citizens, those companies will be jointly responsible for the human rights violations. In the same manner, turning a blind eye on people who use the platform for violence will be deemed a violation of their right to life. In this sense, social media companies have a negative obligation to refrain from violating others' rights and a positive obligation to prevent the violation of fundamental rights. Perhaps to answer David Kay's question, and there are, of course, obligations enshrined in a number of international instruments. The Global Compact of the United Nations, the Protect, Respect, Remedy Framework, and the UN Guiding Principles on Business and Human Rights for the implementation of these principles, the OECD Guidelines for Multinational Enterprises, the ILO Tripartite Declaration of Principles concerning multinational enterprises, and social policy are among documents that aim at securing these obligations. Of course, there needs to be a will on the part of the intermediaries to cooperate with international organizations. Having said that, today we face certain difficulties created by a number of decisions. One of them, as you all know, and is mentioned on the documentation, is the decision of the European Court of Justice on the right to be forgotten decision, and which has an impact on intermediaries as well as affecting users' rights. On the one hand, we have the dilemma of facing right to privacy and data protection. On the other hand, there is the issue of freedom of expression. So how do you resolve this dilemma? On top of that, now we have the European Court of Human Rights decision with regards to Delphi. And these decisions, of course, put the intermediaries in a difficult situation. And And so there seems to be a shift in balancing towards intermediaries taking action in relation to internet content. So this is the purpose of this first panel, and we're going to look into their role and importance. And we have been given a set of questions, and I asked the speakers to address these issues. So I'm going to first start with Miguel Peguera, Professor of Law, who is sitting on my left. And Miguel will tell us all about these decisions, in short, in 15 minutes, if possible, of course, the e-commerce directive and how we reach the issues surrounding the right to be forgotten case and tie it up to the Delphi case. I was aiming to have Gabriele Sage, head of CE policy, Facebook, as the second speaker, but as far as I understand, she's on the way. So on my right, we have Bill Ekiksen, founder and director of E+ Europe, and Bill is working in this consultancy firm based in Brussels, and Bill has extensive all right, okay. Has extensive experience with Google for 7 or 8 years, as 7 years as the corporate communications for Europe, Middle East, and Africa. As Gabriel is here, so after Miguel, we will have Gabriel as the second speaker, and then I'll ask you to address both legal and policy perspectives. The floor is yours.
Thank you very much. Thank you very much for inviting me to this meeting. And I would like to briefly take a look at some of these issues. So my perspective would be a legal perspective, so how intermediaries are protected under the law. And that would affect, of course, open journalism, because there's a risk that they are held liable for third-party content, the content that they are storing or disseminating. And so the law actually established some legal protection for this risk of liability. However, there are different frameworks. So in the United States of America, for instance, there is the Section 230 of the Communications Decency Act that almost exempts intermediaries from any liability, although excluding the field of intellectual property. And in that field, we have, particularly in copyright, the Digital Millennium Copyright Act that established in Section 512 a scheme of so-called safe harbors that protect intermediaries from liability, but only related to the possible infringement of copyright. Then in Europe, we have the scheme in a way inspired by the DMCA, but it's established in the Electronic Commerce Directive that establishes some exemptions from liability for some types of intermediary services. These are mere conduit, so the transmission services, then the proxy caching, and then probably the most important one, also the mere conduit are relevant, the hosting services, those that would include social media and all platforms that host third-party materials. But my main goal here would be to take a look at some weaknesses of this protection. Because on the one hand, within the e-commerce directive itself, we note that this protection is somehow weak. First, because it does not cover from injunctions. And thus, the provisions in the e-commerce directive specifically state that they do not affect the possibility for a court or administrative authority, according to national law system, to require a service provider to terminate or to prevent an infringement. And of course, the availability of these injunctions depends on national law, but there are some injunctions which are prescribed by EU law, particularly in the field of intellectual property rights, and those injunctions may typically consist either on ordering the illicit content to be removed or ordering internet access provider to block the access to a particular website. And those injunctions, of course, should not impose on the provider the burden of monitoring the information, because this is a general principle established in the e-commerce directive. But this is a problem to assess in every specific case whether or not this line is reached. So the European Court of Justice notes that website blocking must respect the principle of proportionality, which is a key question. So in this case, this is a ruling called Telecabel, dealing with access blocking to a website, and the balance must be made between intellectual property rights, ISP's freedom to conduct business, and also the freedom of information of internet users. But second, there is the Court of Justice of the European Union holds a somehow restrictive interpretation of these safe harbors, because it requires a first threshold which is difficult to reach, which is that the information society service, so the provider, must have an activity which is of a mere technical, automatic, and passive nature, which implies that the service provider has neither knowledge nor control over the information which is transmitted or stored. And this makes it difficult to determine which intermediaries actually qualify for this protection because they meet that threshold. Particularly, for instance, in the Delphi case, the Estonian Supreme Court found that the safe harbors were not applicable because this news portal played a role which was not neutral enough. So there's a discussion here. And moreover, the meaning of the key requirements, the key requirements of actual knowledge are not really defined on the directive. So there are two standards: the actual knowledge, or the awareness of facts or circumstances that reveal the presence of illegal material, but those notions are not defined. And again, the Court of Justice of the European Union has established a sort of a standard which is difficult to assess in specific situations, saying that there will be that awareness when the provider is aware of facts or circumstances on the basis of which a diligent economic operator should have identified the illegality in question. So it's an open standard, that of a diligent economic operator, which is not defined as well, and it is for the national court to determine. And then we lack a notice and takedown scheme that provides appropriate safeguards against sending bogus notices or that provides an opportunity for the user to defend the legality of the content. So in this regard, the DMCA provides for a better procedure, although it has been abused as well. As we all know. And finally, within the directive, we don't have a specific protection for linking that is formed for preventing or exempting providers from the liability that might arise because of linking to illegal material, unlike the DMCA again. So some courts have tried to include this activity within the hosting safe harbor, but it is not clear enough as a matter of law. So if we have within the directive some weaknesses, we have in addition some other threats coming from other places, either by courts or either courts' interpretation of the directive, or either by other laws. And here I would like to briefly mention Delphi v. Estonia, which I'm sure most of you are familiar with that. The Estonian Supreme Court held that a news portal in the internet called Delphi was not neutral enough with regard to the comments uploaded by its users, and finally was held liable because of some defamatory character of some of those comments. And the Grand Chamber of the European Court of Human Rights upheld this decision, holding that the interference with the freedom of expression of Delphi was acceptable under the convention because there was the requirements were met, that is, it was prescribed by law, it was necessary, that interference in a democratic society, and it was necessary for the protection of the reputation of rights or rights of others. And of course, this outcome hardly comports with the principles under or behind the e-commerce directive. And in other cases, the European Court of Human Rights did find a violation of the freedom of expression, as Yaham will know, because he's been one of the plaintiffs in that case, in the case of Sending and others v. Turkey. Recently, just last week, the European Court of Human Rights actually found that the blocking access to the whole YouTube platform was a violation of the freedom of expression. In addition, we have, as Yaman said, the right to be forgotten, this right that was recognized by the Court of Justice of the European Union in May 2014, finding that under European data protection law, an individual may request a search engine to remove results that point to contents which include personal information about that individual. So since it is based in data protection law, the court considered that there is no need that the individual actually suffered any harm because of that information. It's just a question of the right to control one's own personal information, as long as some general conditions are met, but those are really vague, so the right may be exercised whenever the information is inadequate, no relevant or irrelevant, no longer relevant, or excessive. Actually, in relation with the processes of the processing, and the only exception is that this would not be the case if there is a preponderant, if the public has a preponderant right in accessing that information by the means of a search using the person of that name. And so far, there have been a lot of requirements asking, a lot of requests, asking for those delistings. And according to Google's transparency report, Google has already received, since May 2014, 354,000 requests. And of course, each request may encompass a number of different URLs. So the total number of URLs so far received by Google requesting to be delisted are of 1,256,000 requests. And out of all the URL that have been already fully processed, Google has agreed to remove 42% of them, and some 58% have been rejected. Of course, in the case of rejection, the data subject may resort to the Data Protection Authority, but only a tiny fraction of those cases are actually appealed there. And then the DPA may either accept, in some cases DPAs are accepting Google's decision to not delist in some cases, and in other cases Google is eventually forced to delist the content. And then a new threat, I would like to call it a threat, although it has also very positive elements, but the General Data Protection Regulation, which is about to be passed in Europe, in the European Union, includes right to be forgotten, which is broader than the one considered by the Court of Justice, because it covers. It doesn't deal with the delisting in search results, but generally deals with erasure of content, removal of content from any internet provider that is processing personal data. The good thing is that, well, those obligations will not apply when the member state has established an exception for freedom of expression or information. But of course, this ultimately depends on national law. It's not in the level of the future regulation. And another good thing is that the regulation, the draft, explicitly states that the regulation will apply without prejudice to the safe harbors of the e-commerce directives. But this may be not enough, first, because it is not clear whether a provider who is deemed to be a data controller under the regulation will be considered neutral enough as to qualify for the safe harbor protection. And second, because even if it qualifies, the safe harbors will only protect it from liability, but the safe harbors do not appear to protect that intermediary from the obligations to put data on restriction, that is to block the access to that data, and to erase the data. So this clearly goes against the ideas behind the e-commerce directive, particularly because the standard is in the e-commerce directive actual knowledge or awareness of factual circumstances, whereas in the regulation, immediately after receiving a request, the provider must put the data on restriction and then start assessing the validity of that request. And this is something that is, I would say, a threat. And finally, linking, and this is the last idea very quickly, linking in the EU, just linking to some material might be considered an infringement of copyright and thus be illegal. And there are some cases pending before the court. And let's see how this finally will turn out. For now, we know that if you link to some content which has been made public by the copyright owner and is fully accessible without any restriction, that's okay, but we don't know yet what will happen if you are linking to material that happens to be there without authorization. And that's all. Thank you very much.
Thank you very much, Miguel, for that. I mean, as you can see, there are more question marks than clear answers, and now we will hear from Gabriela says how Facebook deals with this case law and a number of regulations, and see how that impacts upon issues related to open journalism and users' rights.
Thank you very much. And first of all, I'd love to apologize for my being late. I'm sorry, my flight had been cancelled, so I took an alternative route, which implied some driving, so I'm sorry that was a hassle.
Thank you for making the effort to come
sure.
in here.
You can see that how devoted we are to human rights. And that's a very serious statement indeed. And I would love to talk a bit about how Facebook approaches human rights and what is our commitment and how do we implement these commitments in practice in our policies and in the implementation of and enforcement of our policies. So I will give you a very practical or a more practical view from a company and business point of view. Facebook is a platform of 1.5 billion people, and we seek to provide a platform where people can freely share and surface content, messages, ideas, and they are still reflecting the rights of others. We believe that sharing information and the openness that it results invites conversation, debate, and greater understanding. A free and open internet is critical to achieve that mission. You can't make a world more open if people are prohibited from sharing openly. For this reason, we support policies that facilitate expression. We want people from all over the world, and even in the darkest recesses of the world, to be able to share what they are experiencing so they can have the voice from the ground, even in places where maybe so-called official traditional journalists cannot be present. We believe that sharing information and the openness that it results invites debate and understanding in more tolerant and open societies globally. While most of the people who come to Facebook share benign content on our platform daily, some of the content can be controversial, can offend others, and some might result being a hate speech or be a crime considered by national legislations. When we are reviewing these, let me first talk about what are the policies, what we have, and then what is the procedure, what we take when we are reviewing the content. On Facebook, we have the community standards. This is a concise document which is public, and all of our users must adhere to this document when they are using our platform. This document describes what is tolerable on Facebook, what is welcome on Facebook, and what is not. When we're doing a review process, when someone is reporting, you can report any pieces of content on Facebook. When someone reports a content, then our expert team comes and reviews that content. The content reviewers are judging whether the piece of content is in line with the community standards or not. Our content policy, for example, allows opinions on state institutions. You can criticize beliefs, but you are not allowed to target, attack people based on those beliefs. We have no tolerance for hate speech or content that is threatening, that incites for violence, or that is directly harmful. Sometimes it is very clear-cut what is against our policies and what is not. But most of the cases, especially when we are dealing with hate speech, this distinction is extremely refined, and it is, in a lot of cases, it is a challenge for our team. We need to know the language, we need to know the context. Hate speech is not, most of the time, it's not just there in itself, but it requires an in-depth knowledge of the circumstances. When we find direct statements of hate against particular communities, that violates our statements of rights and responsibilities in the community standards, and it will be removed from our site. Just two quick examples. Occupy Pedophilia was a Russian group that traps gay youngsters through advertisement and assaults them. That's prohibited from operating on Facebook. The other is Kuruc Info in the Hungarian online journal that continued posting content that violated our policies regarding hate speech, and that was permanently banned. It is important to highlight that we operate on a global scale, that we nurture a global community. So our set of policies is global as well. We provide the same set of rules for everyone, no matter where they reside. We do not track one legal system. We want a product to be coherent, and our users are interacting across the borders. When we are talking about freedom of expression, I would like to highlight some of the threats and challenges that we are seeing currently. Before, if time allows, now I'd love to go into two specific things regarding Facebook and human rights. That is real name policy and how we see our community standards and rule of and the notion of censorship of intermediaries on content. But may I just highlight some of the threats that we are seeing currently or in the recent years on a global scale. We see a tendency of overbroad restrictions on speech, such as prohibiting content that is offensive or sensitive. These notions are getting higher, especially in situations like recent terrorist attacks. We see there is a tension between notions of governments and states to regulate intermediaries and platforms in order to provide higher level of security to citizens, but as well that we see that sometimes these attempts infringe either on freedom of expression or the data privacy of the individuals using these platforms. There's a tendency of imposing liability on intermediaries for speech by their users. We see that intellectual property and cybersecurity can be substantive areas which are referred to as a reference point for further legislation and applying de facto speech restrictions. There is as well a growing fear about the consequences of online speech among bloggers, activists, or just ordinary citizens when there is an expanding circumstances under which an intermediary is required to provide data to the government. Then we see a growing urge from governments to have legislation affecting freedom of expression that is often included in laws that propose to regulate other aspects of the internet, as I said. Mainly it regards cybersecurity and intellectual property. These are discussions that we take part very actively. And as I mentioned, for Facebook, freedom of expression is one of the core values that we protect. And whenever we are governing our site, we are doing a balancing act. How can we enable more speech, free speech of all of our users, and how can we provide a safe platform for our users? So whenever we are implying our community standards, the policies that govern our site, this is the balancing act that we are looking for. We need policies that are principles, that are implementable, and that are explicable, by which I'm meaning that when being principled, as I said, we need a global set of standards. When we're saying implementable, that we are a technical platform. Policies and rules can look wonderful on paper, but they have no meaning for us when we cannot implement it by our technical and human resources. So we need rules that are implementable on a global scale, given the fact that we have 1.5 billion users using the platform in various languages, coming from various cultural background, coming from different age groups. And they are posting content on a scale that amounts to hundreds of billions of photos and posts daily. That as well results in a scale of millions of reports weekly. And that is the quantity of content that our review team, that amounts to a couple of hundreds of people in 3 locations in the world, has to deal on a weekly basis. Just very quickly, and I think that will be something maybe for the later discussion, but as it was listed among the topics for this panel, I would like very shortly to talk about real name policy. Real name policy, what we call, let's be more precise, is real identity policy. For Facebook, it's a core element of our platform to provide a safe platform for our users. Real name policy means that we require our users to be present on Facebook with their real identity. We do not require them to provide their ID or to give us a copy of the ID. What we require them is to use an identity that is known by their friends, family, or workmates. So that's how they are known by their community. Facebook is a community of people. We are providing safety for our users by keeping this community of acquaintances, friends, and families. So it is a primary importance that you are there on our platform with your identity. However, there are some notions, again, sometimes on government level, to link your real identity with your online accounts. This is something that we are opposing and that we are not supporting. We feel that for us, on our platform, real name policy has been working very well. This is one of the key of the success of Facebook providing a safe platform for our users. But we do not advocate for a real name policy all over the internet. We see that there is There is a room for anonymity on the internet. There is a room for anonymity to express your opinion, especially when it comes to freedom of speech for activists, journalists, or expressing your opinion in general. So we are not supporting any of those propositions that would, on one hand, link your online account to real name legislation, or similarly, we do not support any of those propositions that would provide for prohibition on authentic names. I think this is something where I should stop, and then certainly usually there are questions to Facebook policies anyway.
Okay, thank you very much for that. So, Bill, how do you assess the whole issue from your point of view?
Thank you very much. I mean, it's interesting listening to your two comments, and my perspective follows. I had some which we'll repeat, but we'll see if I can move on the discussion. Before starting, I wanted to just go back to when I began at Google, which was September 2008. And at that point, I mean, the internet still looked much rosier, much brighter than what you've described right now. Yes, there were some of the issues about copyright. Yes, real names were already an issue. But, you know, with the first 2 years of the time I was at Google, Google pulled out of China to defend free expression. And I remember sitting with Wael Goim, who was marketing manager, and in Cairo. And then a couple weeks later, there was the Arab Spring, and the company defended him. And everyone cheered the internet as something that was going to bring freedom and democracy to the entire world. Free expression was the ultimate, I think, the first value at that point. People thought of the internet, and they thought free expression. They thought it gave everyone a voice, and all the silence. People could finally express themselves. And I think today what we're seeing, if I listen to your comments and my own perspective, is that privacy and security have triumphed over free expression. And free expression is definitely, or seems to me to be, in the third place, almost forgotten when we talk about the internet. And that's the major theme, what I wanted to express. The good point is, I mean, despite all the legal obligations that we've talked about that are being piled upon intermediaries, more and more people are going online. I looked at the figures the other day. More than 3 billion people are online. When I stopped working at Google last year, we always talked about 2 billion. And, you know, I looked at the YouTube figures. When I started at Google, it was 4 hours of video being uploaded, and I Googled it yesterday, and it was at first 300, and then I found 400 hours being put up every minute. So more and more people are using the internet, more and more people are expressing themselves. And I think that's led to a backlash. Governments have really wanted to clamp down control and put more obligations on the intermediaries. I mean, you know, it goes, YouTube is banned. I think Facebook is banned in many countries, but YouTube at least in 17 countries, and it's, you know, China, North Korea, Iran. Okay, they're the usual suspects. But what I think is new, and what we're seeing over the last 2 years, is that it's Western Europe, it's democracies, which this battle is being fought out in the front line, often in courts, as Miguel talked about with these cases, often in pressures, I think, to hand over information about terrorists, be it in the United States or Western Europe, for Facebook and for Google. And let me look at a couple of the key cases, which repeat a little bit. Right to be forgotten. You know, it was pretty clear when I was at Google, Google thought they were going to win that case. They chose the case because there was really no question. It was legal material that was put up in a newspaper that was required to be published by Spanish law. How could a court decide that that was no longer relevant or that you could no longer search for it? Very confident. And I remember when the first case came out, the Finnish Advocate General, I believe it's May 2013, you know, he called, if there was a right to be forgotten, he compared it to Chinese censorship. A month later, Edward Snowden, and a year later, you know, 180-degree turn, and we have a right to be forgotten. You've explained what that is, but and you've explained, and I just wanted to follow up on that, the danger isn't that we'll have a right to be forgotten as it's defined in, what was it, May 2014? Yeah. But in the next couple of weeks, there's a new data protection law, and it'll be much broader under the proposals that I've seen. It will strengthen the right to be forgotten, basically, before there will be no review process, but as soon as someone lodges a complaint, the stuff would have to be taken down. And that means the 58% of people that you talked about that were refused by Google will automatically get their way unless it's overturned, which would be much more complicated. And I've even seen in this the right to, I have some new clients who were talking about archives and the access to archives. Now, there may be an exemption written in, but it's even questioned whether, on privacy purposes, researchers would have access to the Nazi archives, for example. That's the type of place where we're going on the right to be forgotten. And the idea of a right to remember, I think, has been totally squashed and so forth. The next thing that Miguel talked about was the e-commerce directive. And it is true, I think that all the cases you mentioned mean that what we're moving to is an obligation to proactively screen. So as things are now, despite the weaknesses you saw, fundamentally the material should only be brought down if it's found to be illegal once you're notified. And that has been very, very important for the development of the internet, the e-commerce directive. But we are really seeing moves, I think, to make the intermediaries proactively screen. And with some of the cases I was involved with when at Google, the Delphi case that you mentioned, but there's also the Max Mosley case, which French and German courts very clearly rejected the obligation to take it down once it was found and notified, but to prevent it from getting up online. And that type of revision of the e-commerce directive is right now being envisioned by the European Union authorities. I'm in the process of responding to a platform consultation, and it's very clear that the tone of this is to undermine the e-commerce, or the threat is to undermine the e-commerce directive and require proactive screening. So I think that's really the front lines, and both of you identified them. Another danger that I see is data localization. I think that governments around the globe are really demanding that you keep the data within the country. It's not a direct tie to free expression, but in places like Russia, I would say it's for surveillance purposes, but it's also Western Europe striking down the so-called safe harbor agreement, which means to protect privacy again, we're saying that data has to be kept inside one country and not transferred elsewhere, which in my mind undercuts the very meaning of what we were talking about with the internet in the first place, which was free flow of information across borders. We have all these pressures, and I think the pressures of terrorism and what we've seen in Paris over the last couple of weeks are going to result in increased pressures for the intermediaries to take down quickly content or prevent it from getting up that could be linked to terrorists. Again, while understandable to a certain extent, it will put the burden on the companies to do this, and the tendency among the companies, and now that I'm free of Google and on my own, I believe we'll see companies left and right deciding that, Europeans think that privacy and security are much more important than free expression, and we have no choice but to follow that. The courts are telling us that, the legislators are telling us this, so they will be much more eager, or not, if not eager, much more willing to comply. And I see that in what I perceive as companies' reactions to these recent changes and to the terrorist atrocities. To go back, I think that we shouldn't forget straight government censorship either. Turkey, your country, they didn't go through the sort of e-commerce debate or whatever. They demanded that you put censors in the office and take down material that the government didn't like. And they banned your whole entire platform if you didn't do it. So I think that, unfortunately, we're very far from when the time I started at Google and we celebrated China, the decision of China, or the Arab Spring. And we've gone on to a period where the internet and the internet intermediaries are going to be put under increasing pressure and probably too much pressure. And I'd open it up to discussion because I think that's a good place to end or to launch a new discussion. Thank you.
Thank you very much, Bill. Do we have some time for questions, or is it time for coffee? Let me see. We can take a couple of quick questions and comments, and then we'll break for coffee, if any. Please raise your hand if you have any questions or comments on the panel.
We've silenced them. No.
Question?
Thank you, Christian Möller, University of Applied Sciences in Kiel. I was wondering whether there are different, or I'm sure that there are different categories of intermediaries that we are talking about, but I was wondering whether you would make up these categories and whether different responsibilities goes along with those different categories. I'm sure there is a difference between an ISP and Facebook, but is there a difference between YouTube and Facebook, or Delphi? We're talking about Delphi, the difference between a newspaper in the comment section and the Facebooks and the YouTubes and Googles of the world. Is there a difference between a search engine? So how would you see the different categories, and which responsibility, is there a scale of responsibility going along with the different concepts or categories of intermediaries? Thank you.
Do you want to answer that?
Very briefly, because it is, of course, there is a big distinction between ISPs, which generally are held not liable for any illegal content they transmit, but they can be obliged to prevent some traffic or to stop or to block access and so on, and those are the questions which are discussed there. And then there is a general legal framework in the European Union covering every provider that hosts, that stores content uploaded by users. That would include comments in newspapers, updates in Facebook, new videos in YouTube, everything. But this is just to exclude liability. Then what if they are not protected by this safe harbor? Will they be liable? That will depend on national law and will depend on the nature of the illegality. It will depend on the laws dealing with defamation or dealing with copyright or dealing with hate speech or whatever. So there are there's a big range of different substantial law that will interfere there, but they are all covered if they reach this threshold and meet the requirements of the e-commerce directive, basically removing the material once they have actual knowledge of the illegality.
Just to add to that briefly, it's for many years there were three categories: users, hosting providers, and then access providers. For many years that worked until these problematic decisions were issued by the European Court of Justice and the European Court of Human Rights. I think it's time to revisit these definitions and expand upon them. Yes, you're right. A search engine is different than Facebook. Facebook is different than Twitter, although they have some similarities. I mean, Gabriel, do you speak to other social media platform providers in terms of common solutions? To YouTube or
Depends
Twitter?
on common solutions to what, because that's exactly what we see. You mentioned the platform consultations, the ongoing platform consultations as part of the digital single market discussion in the European Union. And the whole notion of having a platform regulation, we think is entirely wrong, exactly because all these companies and all these services that provided by the so-called platforms are so differentiated. They are so different in nature. The one thing common is that they communicate from one group of users to another group of users, but that is something that you have in the real life as well, so that is not something specific for the online world. So it depends on question to question, territory to territory, where you are forming the groupings between different providers. When it comes to freedom of speech, what is really important, whether who is responsible for the content that is uploaded on the platform. We see that, like Facebook, we are providing a platform for user-generated content. It can be a private individual. It can be a blogger who operates or manages a page, which page is a public content, and there he or she can have a moderating policy. Or it can be a media outlet who is a professional provider of content, and they are using our platform as well via instant articles or having a page. So that's one thing is common here, that Facebook is just providing platform, but we are not responsible for the user-generated content till we do not have the new European legislations which are in the pipeline.
Yeah, I would add just one thing. I think if you look at the platform consultation that the European Union has sent out, it has a very broad definition of platforms. It goes far beyond the user-generated content. Netflix becomes a platform, even though, to my mind, it's a subscription service that is no different than going to a video store. So I think you're asking a good question, that the definitions need to be refined. The other thing that's clear is that there's a lot of pressure on certain big American players more than anyone else. You know, at Google, to go through 1.2 million URLs, and the right to be forgotten to be directed at one search engine seems a little narrow, when I would consider Facebook a search engine, or Amazon a search engine too. If you're searching for products, or Facebook, you're searching for people. So I don't know when you'll have to comply with the right to be forgotten as well.
The time will come.
Yeah, I think so.
Yeah. Yes, and then we'll have coffee. Yeah.
So to answer your question, I guess I'll ask another question. If we start differentiating, will we then run into a slippery slope of yeah, so for me, the question is, well, it's not okay for Delphi, but it is okay for Facebook. It's not okay for this, but it is okay for this, and who defines who's a good intermediary and who's not? So I guess for me, my question is, how do you differentiate like that in a way that's not, we're not creating a slippery slope?
I mean, I totally agree with you. I mean, I said we need to revisit these issues because of the problematic decision, especially if since Delphi. I mean, we can, of course, ignore Delphi to some point and hope that the European Court will revisit the issue. Because until then, the issue of actual knowledge, especially in terms of removal of content and notice and takedown policies, to some extent worked in the Western European countries, although wherever you look, you face problems. But since Delphi seems to ignore the actual knowledge principles and require a more constructive knowledge and requires companies to take action. I mean, just read the dissenting opinion of Professor Shire on the Delphi case, and you'll see a discussion of these issues. I think he got it right, and the court, the majority, got it wrong on that point. So we face this dilemma now to resolve these issues. And my view is to ignore Delphi and continue as before. But there are these questions rather than answers.
There seems to me to be a fundamental difference between platforms with user-generated content and platforms or services that offer edited published materials or videos that they paid for copyright for.
Just imagine, aside from the question that when you're operating a page, then the page admin has the full right to have a moderation policy. When we see our full site, we have our community standards. Anyone can report a piece of content, and then we are reviewing it. But just imagine that on Facebook, there are 400 million photos uploaded daily and 600 billion posts posted on Facebook in form of shares, comments, likes, and posts. There is no way to have a team that would, if we have filtering and monitoring, if we would have a filtering and monitoring requirement, to have a team that would screen every photo of a newborn baby or every photo of a morning coffee, every happy birthday or happy Valentine wishes on our site, and then giving the clearance that, okay, you can go ahead, you can post it now, your post is visible to your community. This just wouldn't work. That's clear. And maybe just one notion of, we haven't talked about encryption. This is something that we see as well as a challenge and a high-level threat to freedom of speech that connects to data localization issue. And the other is a heckler veto, when making a fine distinction of what is incitement and what is real hate speech. And we see a growing notion to take down or requirement to take down some content just because too many people do not like it. And this is something that we very strongly oppose because we deem that that would amount to heckler's veto. But this is something that we see as a tendency.
Just to add one thing, I mean, I hear the argument that there's so much material being uploaded, and I've mentioned it, that it's impossible to review and prevent, but I think the internet companies are going to have to move on from that argument because they're doing it for child porn. Yes, I personally agree that it's more these other situations, right to be forgotten or political speech, are much more difficult. But I think the idea that we aren't going to be using algorithms to moderate what gets up and what doesn't is coming, and we should probably find the best way to limit their use to what is pretty black and white, rather than saying that we can't do it because there's too much.
Okay, coffee break then. 15 minutes, and then we'll be back here continuing with the discussion.